Good morning, good afternoon, good evening. Welcome, dear colleagues and friends, to the 5th CPLJ webinar. And we will again address issues of methodology in comparative procedural law. It's a great pleasure welcoming all of you and the two speakers of today, Ralph Michels and John Haley. The first speaker will be Ralph Michels. He is a director of the Max Planck Institute for Private International and Comparative Law in Hamburg since 2 years. And since he started there, he launched many projects. And one of them is also the Colonial Comparative Law. And this was a reason why we thought it might be a good idea to invite him to look at our project a little bit from the perspective of the colonial law. And I don't think that I have to present Ralph more. He is well known on both sides of the Atlantic, as he was for several years a professor at Duke University. And he is someone who liaises a little bit the Europeans with the Americans. So he is familiar with both worlds, let's put it that way. And therefore he is an ideal presenter of a topic which addresses comparative law. Ralph, you have the floor.
Okay, thank you very much both for introducing me and for letting me take part in this really very promising endeavor on comparative procedure that you are starting, and that looks grand and comprehensive and really paradigm building probably. And so it's a great and somewhat daunting opportunity to maybe be able to have a small impact on it in the beginning. You said I have contacts to both worlds, the United States and Europe. And it's true that I have contacts to both those worlds. And it's true at the same time, and maybe John in his other presentation will also talk about that, that of course those are not the only two worlds in our world. And indeed, within the project of decolonial comparative law, one of the big challenges is to move outside of dichotomies of civil versus common law or American versus European law. And I must admit, quite frankly, that my expertise, my substantive expertise in these other legal traditions is much lower. So what I try in the project on decolonial comparative law, which I am directing with a colleague who's now at Oxford at the moment, who was here for a year, Lina Salaimi, who was at Tel Aviv University before, is largely methodological at this point. But it is an attempt to break up from our own perspective, which is a global north perspective, lay out possibly certain blind spots that we have, and develop a methodological approach of comparative law that is more just, more appropriate for a truly pluriversal world. The presentation that I'm going to have today is far less refined than yours was, Burkhard, when you presented the whole project in our series here. It's also less refined than I would like it to be, because Lina and I are at the moment working on our, so to speak, methodological foundation paper. But with the pandemic and myself having to be managing director here, that's been pushed to the back a little. So unfortunately, the presentation will be much more abstract and general than I would have wished it to be. Maybe it's nonetheless a basis for discussion, at least, because I'm going to try to throw out some themes that maybe have a way of inspiring debate, discussion, or at least consternation, surprise, and disdain for the speaker, which is always also productive in some ways. What I want to speak about in this is Chevron mostly. That is, I want to present the big Chevron litigation in Lago Agrio in Ecuador as a fabulous case example, really, for comparative law, including very strongly comparative procedural law. I'll present that twice, in fact. That is, I'll first present some of the issues that arise there in comparative procedure. I'll then move out of that and talk a little about the promises and the challenges from decolonial comparative law. And then I'll try to come back to Chevron and mention just a few issues, a few starting points on the Chevron case, which can benefit, I would think, from a decolonial perspective, more than from what might be a classical comparative law procedure. All of that, as I said, too general, too abstract, somewhat too tentative, but I hope that the procedure experts in your group can make something of it regardless. The Chevron case, to start with that, everyone is presumably familiar with it in some ways, concerns an oil pollution around the Lago Agrio area in Ecuador in a joint venture between the local Ecuadorian oil company and Texaco at first. Later, the litigation is Chevron, which took over Texaco. That's why the cases are Chevron, although the pollution is related to Texaco. The case then arises from times at which we had blatant, you could say, exploitation of the global south by the global north, in the sense that countries like Ecuador were really polluted badly in favor of petrodollars, because that was one of the main economical benefits in a country like Ecuador, the benefit of a few in Ecuador to the detriment of, in particular, local and indigenous populations. And of course, to the benefit of oil-hungry economies in the north and companies benefiting from that, like Texaco or indeed Chevron. What we find as a response to this pollution is a series of litigations. In fact, I think the Chevron affair is so large and so comprehensive that possibly every single issue in comparative law and in comparative civil procedure arises somewhere at some point in this litigation. This is a litigation that at some point has 1,000 lawyers allegedly working on the case on the side of defendants, 1,000 lawyers worldwide. Why is that so? Because Chevron decided here not to go the usual way that you go in this kind of environmental litigation, which is to basically settle with the plaintiffs to get this over with, but decided a real aggressive strategy, trying to deter not just these plaintiffs, but any other plaintiffs by throwing billions and billions of dollars at the case in order to get rid of it. So it's a really dramatic case. It's a really dramatic series of issues. I'll introduce the case and I'll talk about some of the traditional comparative law issues first. So it starts this story for me with a case, class action brought in New York, as you would, Aguinda against Texaco. Class action here brought in the name of local indigenous people in Ecuador, but of course brought effectively by a US attorney, as you would. This demonstrates the role of US courts as world courts, really, because we have a litigation that does have a US defendant, but in almost all ways is much closer to Ecuador than it is to the United States. But the plaintiffs think, or the plaintiff's lawyer thinks for good reason, that this case has more potential in the United States than it does in Ecuador. The United States allows for class actions. The United States allows for punitive damages. And so this is one of your classical, if you want, environmental litigation class actions brought in the United States. The defendants do what you normally do in these cases, and they bring a defense of forum nonconvenience, suggesting that the case should be heard in Ecuador. And the plaintiffs bring a number of counts, two of which are interesting from a comparative law perspective in particular. The first, so-called Law 55, which is one of typical Latin American, you could say, anti-forum nonconvenience statutes. That is, such laws say that once a suit has been brought abroad, in particular in the United States, Ecuadorian courts will lose their jurisdiction over the case, suggesting that once the case has been brought, even if it's dismissed under forum nonconvenience grounds, it can no longer be brought in Ecuador. And of course, the promise of such statutes is, perversely, you could say, that one of the requirements of the forum nonconvenience defense, that is the availability of an alternative forum, goes away. And these statutes are indeed meant to do that. They have a certain doctrinal background in a civilian approach to parallel proceedings, but they also have that explicit political aim. Interestingly to say, for Latin American countries, we'd rather that these cases be heard in the United States, then they be heard in Latin American courts, precisely for the plaintiff's advantages that I just named. That's the first defense that is not accepted here by the court. And sorry about that. And that is dismissed, as it often is in US courts, because basically they say our doctrines are not dependent on what other states say. The second is a suggestion by the plaintiffs here to contend that Ecuadorian courts are subject to corrupt influences and are incapable of acting impartially, and that is also dismissed. The defendants and the court suggest that this is actually discriminatory to all Ecuadorian courts incapable of acting impartially. The fair thing, they say, is to acknowledge the high quality of Ecuadorian courts and therefore to allow the forum nonconvenience motion to go through, which indeed it does. Of course, what happens, as you know, in consequence, are two things. The first is somewhat unexpected in forum nonconvenience proceedings, because up until around that time, the forum nonconvenience dismissal was effectively a dismissal altogether. Cases were usually not brought elsewhere in the alternative forum. That is, much of that was just fictitious. You would usually not bring the case in the alternative forum because it was not attractive enough. In this case, that was different. The government in Ecuador shifted from a right-wing to a left-wing government that passed a new law, in fact, here, law on environmental management, and we created an entire legal procedure for this particular case to enable this case to go through and to possibly lead to a positive result for the plaintiffs. As indeed it did. The first instance gave a judgment of $19 billion against Chevron on appeal that was halved to $9.5 billion. Still a completely extraordinary sum of money in a damages judgment. Not, by the way, as far as I can tell, punitive damages, but actual compensatory damages, suggesting that the damages to the environment are so enormous. So this judgment comes through as a big shock, of course, and the plaintiffs immediately begin enforcement actions in Brazil, Canada, Argentina, not in the United States, because they fear that the judgment will not be enforceable in the United States. And indeed, that is true. If you go to the next stage in this here, it's not Danziger, but Danziger, we find that Chevron brings a declaratory action in the United States, in the Southern District of New York, asking the court for two things. One that is less dramatic and the other that is more dramatic. The first, that less dramatic, is a declaration that the judgment cannot be enforced in the United States. That's fairly common. You don't wait for the recognition proceedings to start. You have this immediately declaratory judgment. The second is more unusual. They ask for a worldwide anti-enforcement injunction. That is, they ask the court to enjoin the plaintiffs from enforcing the Ecuadorian judgment anywhere in the world. This, as you can see, is quite different from an anti-suit injunction. The anti-suit injunction tries to preserve typically the proceedings in the forum against competing proceedings in another forum. It can also protect arbitration against proceedings elsewhere. Here, the anti-enforcement injunction really protects the US defendants from the plaintiffs making use of their, by and large, valid title. And indeed, the Southern District in New York, in this case study, the most one-sided court that I have seen, I think, in proceedings of this kind, indeed grants this unheard of worldwide anti-enforcement injunction, which enjoins the plaintiffs from enforcing their judgments with the consequence of damages. That is, if they find the $9 billion in another country, say Argentina, they have to pay them back through the New York court. That part is not upheld on appeal, but the unenforceability is indeed upheld. The other venue where Chevron goes, this is on the slide, I don't know why, I apologize for that. The other venue where Chevron goes is arbitration. Quite early on, goes to the Permanent Court of Arbitration in The Hague. And that court gets involved quite early. Already early, as interim measures, as you can see here, all measures that it's disposed to suspend or cause to be suspended the enforcement or recognition within and without Ecuador of any judgment against Chevron in the Lago Agrio case. That is then upheld in the awards. The important one here is 2018. The judgment is not enforceable. Now the Permanent Court of Arbitration then, and damages are given to Chevron against Ecuador. Why? Because indeed both courts, both the Southern District in New York and the Permanent Court of Arbitration hold that it is in fact true that Ecuadorian courts are corrupt and are subject to bribery. So the precise arguments that were rejected on the forum nonconvenience case at first are now being upheld in recognition proceedings. To some extent on the basis that circumstances changed, indeed that the government changed, to some extent on the basis that they have indeed evidence. The plaintiff's lawyer is so careless to show a whole documentary film by which he wants to demonstrate the strength of his case. I mean, what plaintiff's lawyers do is try to get a lot of goodwill. You establish a website, you establish a film, etc. And the film shows them, in fact, talking about how they bribed the judge. It is virtually certain that both sides tried to bribe the judge in Ecuador. But of course, plaintiffs themselves put this on film, and that was proof enough for the Southern District in New York against the enforceability to say there was fraud. It is enough for the Permanent Court of Arbitration. And it's indeed enough here in Chevron 6 to actually go after the plaintiff's lawyers himself, quite unheard of. The civil judge in the Southern District of New York starts criminal contempt procedures against Stephen Danzig, against the plaintiff, puts him in house arrest, privately appoints a friend to run the criminal contempt procedures. And indeed, the lead counsel is, as far as I know, since then is under house arrest. The other astonishing thing is that the court orders him in these proceedings to disclose all his own materials on the case to Chevron. That is the usual privileges, attorney's privileges over your own materials, confidential conversations, etc., is overruled. It's no longer holds. Effectively, Chevron has access to all the preparatory materials of the plaintiffs, which of course means that the case is dead from the start because they can defend against that quite easily. So those are basically the proceedings. They still go on in some ways. Danzig is still fighting in court. The court in The Hague just upheld the Permanent Court of Arbitration last year. But those are basically enough steps, I would say, to understand those proceedings. Now, what is in such a case for comparative law, if you want? There's a number of topics that are quite straightforward and quite easy to see. One of those would be issues, of course, of traditional comparison between a common law system in the United States and a civil law system in Ecuador. Add to that the Permanent Court of Arbitration, which of course is somewhere in between. So you have things like the forum nonconvenience, which is a doctrine of a common law and not of the civil law. And in connection there with these immunity laws, Law 55 in Ecuador as an interesting object for comparison. Anti-suit injunctions, the same, or anti-enforcement injunctions as something characteristic, you might say, of a common law proceedings and not of civil law proceedings, etc. So those would be a number of themes that appear from such a case. The second set, and that's something that I've found interesting in teaching comparative law recently, is to view the applicability of doctrines, in particular of private international law, as actual spaces for comparative law. So in a forum nonconvenience decision, if you have to determine whether an alternative forum exists and whether it is adequate, and you have to necessarily, and whether it is more appropriate than the forum, you have to engage in comparison. So the judge in such a case, in the Texaco case, in the Aguinda case, has to engage in comparative law. So the cases themselves become material for comparative law endeavors. The same is true for the recognition and enforcement proceedings, because in the public policy exception, you have to address questions of comparison. You compare the foreign law and its application to basic standards of the court where enforcement is being sought. And of course, another part of internal comparison, if you want, is to say why is corruption not accepted for forum nonconvenience purposes, but is then accepted on the recognition and enforcement stage. So how can it be the case that a US court says this case must be heard elsewhere and then refuses to recognize the judgments from that court that it itself has appointed? But there's also fairly traditional comparative law themes, if you want. The third is one here of that is inside the judgments, and that is the idea, if you want, as some scholars have called it, as Latin American law as the always failed law. That is an idea of an inherent superiority of global North law over global South law. But it's this idea that is a general idea and often becomes a stereotype of global South courts as inherently corrupt, as inherently providing lesser quality of justice than global North courts. That's the one point that, as you could see, appears interestingly in reversed roles in the foreign convenience proceedings and then later in the anti-recognition cases. But it's a standard understanding that we have, and if you want, a standard ideology that we have, that global South proceedings are just inferior. We find that indirectly also in the human rights arguments. That is, the corruption argument is very strongly a human rights argument in the sense of standards of civil procedure. And those are standards that can be argued that emerge from experiences in global North courts, be they in particular due process rights in the common law in the United States, but also similar provisions, Article 6 of the European Convention on Human Rights. So we have standards that come from Europe or the United States and that are universalized. So those, if you want, are some standard themes here in comparative civil procedure. I see I'm needing a lot of time. I will rush even more, but I think I'll manage that. I'll speak more briefly than I thought about the theory of decolonial comparative law, maybe, and more about the challenges of that. What do we try in decolonial comparative law? We try to adopt a theory that emerges in particular from Latin American thinkers and theorists outside of the law, and we try to apply that to comparative law. I'll maybe skip over some of my slides because they are too rich and too complex. Now I'll just mention some issues that emerge from the idea of decolonial theory. The first is, and the first important idea behind decolonial theory is to suggest that modernity and coloniality come together. What does that mean? That means that first in terms of time, that modernity and coloniality, now understood as colonization, emerge almost exactly at the same period, say around 1500, when we find on the one hand colonization of the rest of the world, and on the second a huge boost, a huge modernization in our understandings of law. The School of Salamanca, as one started, is really involved in both of those developments. And so what we find since then is that the modern, and that includes modern law, it includes modern laws of civil procedure, it also includes modern human rights law, is always defined as against two things. First, it is against the ancient. So the modern is that which is different from that was before. And the modern is secondly always defined as against the other. That is, the modern is defined as European, as against the barbaric tribes that we find in the colonized world. Something that we find, you see, as you know, still in international law, when it is talked about customary international law as being based on the practices of civilized nations, this dichotomy of civilized versus uncivilized is one that we get into that. This dichotomy of developed versus developing or underdeveloped is another such dichotomy. So that means here modernity happens not as a general temporal development, but also as drawing a distinction that did not exist before between what is preferable, which is the modern, and what is to be rejected, which is both the ancient and that in other legal systems which are not as far in development as the global north already is. And so suggests a theory, modernity comes with this idea of coloniality. Coloniality not understood as actual physical colonization, but coloniality understood as a way of thinking about the world. It is of thinking about the world in these types of dichotomies and hierarchies that are definitional then, and in which the modern is considered superior and allowed to take over the non-modern. So that's the justification of colonization when we have colonization. It's the justification of universalizing certain standards that are northern in origin and universalizing them on the rest of the world. Although, of course, all of the developments in Europe, in the United States themselves emerged from contingent specific struggles in those countries, and must in the first step be understood as against those struggles, they then are universalized and imposed on other systems that do not share these struggles and do not share these same situations. So there are two problems in that, if you want. The first is the imperialist colonial taking of imposition of values of the global north on the global south. And the second is the universalization and the abstraction of these global north values from their specific contingent European or American origins into values of universal application. So decolonial theory sets against that an idea of pluriversality. Pluriversality, actually an idea that we find also in global northern literature occasionally in the United States and in a less attractive way in Carl Schmitt. But the suggestion here really that we have in radical pluriversality, we give up the idea of a neutral perspective from which we can formulate universal standards, but instead allow for radical pluriversality of perspectives, of experiences, etc. I won't have time to explain in depth why this is not the same, why this does not collapse in mere moral relativism. Except to say this much, to say the starting point is to say a situation in which in a conflict between different values, one side arrogates to itself the superiority of its own values on a basis that is not outside of them, that does not transcend these two positions, would be unjustified. So in a simple way for a US court to say to an Ecuadorian court, you do not comply with our own standards of justice, is justifiable with regards to the US context, is not in itself justifiable with regard to universal assessment. A universal assessment would need to reach a standard that transcends the US standard and the Ecuadorian standard. But if that outside standard is a human rights law that itself emerges from particular experiences, is itself a transfer from US law to human rights law, then we do not find this transcendent local position. And in fact, I would suggest that that this is a situation in which we find ourselves in this world, because we do not have these universal neutral positions. What we have indeed is a mutual negotiations. As a private international lawyer, I find that mirrored in private international law itself, in fact, because private international law operates in this decentralized way, in which you have to negotiate positions, none of which is superior. But that would be the challenge from decoloniality and from decolonial comparative law to allow this radical pluriversality, which means not just we have diversity of legal systems, but also means that we cannot find easily a neutral objective evaluation of objective standards that suggest which of those is superior to the other. It does not mean that we give up such standards. It just means that those standards can be developed only in conversation and not unilaterally. Related to that in decoloniality is an idea to take seriously the actual colonial background of much law in the world and the post-colonial power structures that we see in law today. That is, to take colonization itself, to see the extent to which laws in the global south are consequences of colonization, which does not take them away, which does not mean the need to go back to pre-colonial procedures. That's impossible, but which requires taking seriously the fact that these laws, these procedures they originate in one set of countries and they are not original to another set of countries. And so we need to be open, not just to the coexistence of other structures. We find that in Latin American constitutions now, they try to give more value to local indigenous laws, but also to the fact that these procedures themselves are imposed transplants at some point, and so do not operate in the same way as they did than the original system. That's the consequence from actual colonization. The consequence of today's power imbalances are more subtle, but also need to be seen. If we see conditionality programs of donors, which make the availability of loans dependent on the passing of certain legislation, then we can see the same kind of imposition, now not through colonization, but through conditionality programs. And so again, we have here laws in the rest of the world that do not originate either from those countries or from a free decision to adopt those, but are indeed instead still imposed in this sense, still come from the outside. The third aspect of that would be mere power imbalances, something that we see in the Chevron case, where the defendants can afford 1,000 lawyers to work on the case and can afford so much money in the case that the plaintiffs just do not have the chance to operate with that. I think that is relevant in comparative civil procedure more generally, these institutional and indeed financial backgrounds. One of these is we have a firm, an English firm, that provides an expert opinion for the plaintiffs on the actual pollution in Ecuador. The defendants buy that firm. They decide to purchase the firm just to make sure the firm will no longer give evidence in proceedings. So it's like in criminal law when you marry your accuser, so you can no longer say anything against it. Here, they actually go out and buy an entire firm. So Chevron really says we throw all our money into that. So that then translates into that. But fourthly, really, and importantly for methodological purposes, what we have to ask ourselves is to what extent are the concepts that we use in comparative law, what extent are those really neutral, to what extent do they not replicate colonial and power structures? We try in comparative law generally to find neutral terms that do not emerge from one legal tradition or the other. And that's mostly in, a lot of that happens between civil law and common law, where it's relatively unproblematic. It becomes more problematic in contexts like these. Take this one example. When we talk about law, we usually assume state law. So intrinsically, even though we abstract here from explicit state legal systems, we intrinsically impose a hierarchy of state law over non-state law. If we think of institutions like civil procedure, and we think of certain institutional frameworks that include a court, that include attorneys, that include systems of appeal, etc., we no longer may lose sight of other sets of proceedings. I believe Oscar Chase has talked about such proceedings already. But we also are at risk of implementing a hierarchy between the modern and the non-modern, to say, yes, we can account for those, but only insofar as they comply with the standards that emerge from our own understanding. So that's the risk of colonial epistemology, if you want, the sense that the proper understanding of institutions and laws in the world happens through these particular concepts and understandings. And that means, lastly, of course, decolonial comparative law is necessarily also political in the sense that it needs to unravel and uncover these underlying power imbalances, both in actual power and in epistemological power. And so proper comparative law, proper global comparative law, in that sense, would also have to be political and would have to take into account actual political and economic situations, in addition to cultural diversity, and etc., to which comparative law is traditionally more overt, more open. So I'll jump through all these slides, which say some of these things and some really different things, but they have beautiful pictures anyway. Let's just say a few words about the Chevron case, and then I'll finish because I'm already over time. And maybe those are useful. It's some themes that emerge, would emerge from a decolonial analysis of the Chevron case. The first would be, how do we properly introduce pluriversality into an analysis of comparative law? We can see that the diversity of legal systems does not actually lead to pluriversality, because the existing power imbalances lead to dominance of US law and US-based law over Ecuadorian law, and certainly over indigenous laws. We have the idea of US courts as world courts that is implemented quite actively through issues like anti-suit injunctions, etc. And so effectively, we find that universalization takes place indirectly in US courts. It takes place directly where we have investment arbitration in the style of the Permanent Court of Arbitration that emphasizes here capitalist interests of defendant corporations over sovereignty interests of a state like Ecuador and interests of local populations like the indigenous populations around the Lago Agrio. And of course, even where we look at relations between the United States law and Ecuadorian law, we lose out of sight, presumably, non-state laws and standards and procedures in that analysis. That's the first thing to look at to go more radical in decentering and through reversality and realize these power imbalances that are at stake here. The second would be to look at the existing power structures in these existing doctrines, and I think I've named those already. An anti-suit injunction that clearly establishes a power structure simply because a US court has ways to enforce such an anti-suit injunction. Whereas an Ecuadorian court, even if it had such an anti-suit injunction, presumably wouldn't have ways of enforcing that. These investments are set up in ways that Texaco or Chevron does not really have assets in Ecuador. So the Ecuadorian judgment is not enforceable there, and an anti-suit injunction would not be either. So with economic superiority comes effective power superiority of your legal system. A US court can have its decisions enforced because at least bigger multinational actors almost necessarily act in the United States, whereas local actors do not. We find, of course, interesting developments now in environmental liability cases being brought in Europe, where courts are willing to hear cases from plaintiffs in Latin America, in Nepal, and other such places. But so the courts where the assets are more favorable here to plaintiffs than they are in the United States. But still, you have to go to the courts where the assets are, which introduces this imbalance. And third, I just mentioned these courts of proceedings because Chevron's strategy has really been to throw money at the problem until it goes away, regardless of the law. So there's a limitation of the law altogether because of its dependence on actual financing. And third then is to, coming back to the pluriversality, to ask to what extent we have implicit standards that favor global north over global north, or that favor capitalist interests over local indigenous interests. So the different standards here that I mentioned between the form and convenience test and the recognition enforcement test. The form and convenience does not fail from the claim of corruption in the Ecuadorian court, but the recognition enforcement does so. It can also be read as a double standard to say local cases in the United States should be heard, foreign cases should not be heard, and they should not be heard anyway. So we have a clear, if you add to that the anti-enforcement injunction and possibly the anti-suit injunction, we have a clear position here taken in the courts to say we are willing to account for local plaintiffs. We are trying aggressively to protect our own corporations procedurally in the rest of the world. So there is a clear double standard once you start analyzing these doctrines that look neutral on their face in the way in which they actually play out. And the second, and I'll close with that, is the question here of human rights and due process. Because as I explained, on the one hand, the due process rights of Chevron are emphasized throughout these proceedings. They're emphasized in the Ecuadorian courts, although of course the Ecuadorian court dismisses those. They're emphasized in the foreign non-convenience dismissal. They're emphasized especially in the recognition proceedings in New York and in the Permanent Court of Arbitration, and indeed lead to the non-enforceability of the Ecuadorian judgment. What is not recognized here in an almost shocking way are the human rights of the local indigenous populations in Ecuador, and those indeed of the lead plaintiffs' counsel. The due process violations of Stephen Donziger remain an object of consternation, I would say, looking at US procedure, how this is in fact possible in a system that otherwise praises itself on protecting attorneys very highly. The human rights or the environmental rights of populations in Lago Agrio, everybody deplores. Everyone in these proceedings always says, too bad that they cannot have justice, too bad that they have to live in these oil polluted areas. But we are washing our hands, quite literally, you could say, of this, because through these particular procedural means, we come to the result that no one is actually going to be held liable for that. So we have implicitly here also a prioritization of certain due process rights over due process rights of others as a consequence of the application of civil procedure institutions and doctrines. And then again, I would suggest is something that traditional comparative law might not properly recognize, and decolonial comparative law with its move against hierarchization and taking seriously pluriversality is able to uncover. So my plea then to the project is indeed first to account for these political and economic background conditions under which litigation and civil procedure takes place, and account for them both in the analysis of the actual way that the law plays out, but also in the way in which it influences our epistemological approaches to comparative law. And secondly, of course, to see to what extent decolonial comparative law as this approach might be a helpful approach to uncover those and lead to a comparative picture of the world of civil procedure that is more open to true diversity and pluriversality, and therefore both more adequate in its description of the world and more just in providing a foundation for how we move from here. Sorry, I went longer because there was so much to share. I hope that was of some use regardless. Thank you.
Ralf, thank you very much indeed. It was very interesting, and it was a very nice combination of a concrete example. Chevron litigation, of course, is a great case, and also the wider perspective, the different, or I would say the different perspective of decolonial comparative law. And I think this was a little bit an eye-opener for us. I have seen that there are already many hands raised, and we will start the discussion immediately. There is only one point where I would say there is no double standard in this case, and this was a forum non-convenience test and the recognition, because the forum non-convenience test was a rather abstract test, and when it came to recognition, it was there had been a corruption, and this makes, of course, the two situations a little bit different. I would like to collect a little bit questions, and then you get the floor for 1 or 2 reactions if you agree. So I see many messages. The first, I would ask Judith Resnick first to ask a question. Then.
Sure, thank you. It was really interesting. My comment is not US centric, but US based, which is that the no liability immunity from misbehavior is a standard that the United States Supreme Court is expounding in domestic as well as non-domestic settings. The United States, we're in an era when the United States has US federal courts have insulated corporate power from employers and consumers who cannot bring class actions but have to go single file to the dispute resolution programs that the companies have created and virtually no one uses. The United States Supreme Court has immunized police officials in our good faith immunity. There's a host of doctrines, I won't go through them, so that the Alien Tort Claims Act, which some of us call it, from 1789 is of a piece with as currently interpreted, excluding plaintiffs from access to redress is the modus operandi of much of the US Supreme Court's current law. So on the comparative perspective and the plurality concept and the questions, one is just how to get a grip on when the concerns are transnational and when they echo national concerns. The other, just as you were talking, I kept thinking about the mixed courts of Egypt from the 1900s and business entities, and their role in both colonial, decolonial, and whether there's any role to retrieve for these mixed entities to do something more useful than their history, or whether they're, I see Margaret saying no, irretrievable in their history, but I'm just trying to think about creative institutional creation that isn't self-serving for the colonials. So that's a comment and a question.
Thank you very much. I also...
Sorry, Judith, can you say exactly what the question was? I noted this as a comment.
Two questions. One is, how do you conceptualize in the category of colonial, decolonial, when, I mean, you can clearly call the US colonial in its own interior, so that a lot of its liability, non-liability doctrines could have colonial caste, as caste is very relevant, but it could also, the question is whether you're exploring cross-border transactions or domestic ones. And the second question is whether institutions that were generated by colonial powers in the past have any retrievability as a modus or a model of trying to think through multi-sided dispute resolution that breaks boundaries again in a certain way.
Maybe Genevieve Sommier may ask a question, and then I hope you get a moment for answering.
Thank you, Burkhard. Thank you, Ralph. That was, as usual, very interesting and provocative in a way. And I have two quite unrelated questions. The first one is, and it goes back to the introduction, right, of you having maybe a foot across the Atlantic, but, you know, and I know that you weren't using the word colonial in meaning a space or a time, right? You were thinking about it more as a concept. But I've always found it challenging to think about, you know, how do we think about Canada, which is my country, but also the US, you know, who of course were colonized, right? But were never perceived as being victims of colonization or as, and I find that when using that language, right, how is it that we distinguish Canada and the US from other states? If we're trying to avoid dichotomies, I find that it's difficult to place those. And my second point relates to Chevron. I mean, of course, it's an extraordinary case, but to a certain extent, to me, it seems, and perhaps I'm mistaken in this, it's such an outlier, right? Everything about that case is absolutely incredible, right? From this, you know, the stakes, from the, whether the stakes from the plaintiffs or the defendant's side, the complexity of the different, you know, ways in which the litigation, the arbitration, everything has taken place, the behavior of the parties, right? You know, Donziger, I mean, the fact that they filmed, right? So it's such a case that, and to what extent can we really use it as an example of anything? Is it just, so maybe, like, to me, thinking in terms of, you know, perhaps our project looks so pedestrian, right, compared to what you're talking about. But to me, when you're doing the comparison, when you're thinking comparatively, I tend to approach it to look at the average case, right? So how are these issues relevant for an ordinary type of problem? And the risk of looking at Chevron is that there's nothing that we can use it to compare because it's such an outlier. Thank you.
Thank you both. And of course, it's always wonderful and daunting to have admired people in the audience and then even asking questions. Let me start with the last one. I think Chevron is an outlier, and the question then is always, because it's such an extreme case, and the question is, can you see in the extreme case more clearly than in what you call the ordinary case, the problems and challenges? Some of the challenges in Chevron come from its transnational nature, and many ordinary cases are not transnational, so that's certainly different. Otherwise, I would say that's an open question, whether Chevron is the exception or whether Chevron is just the epiphany of what goes on there. For me, I think it's an interesting case because it raises so many issues, because so much gets litigated that doesn't get litigated elsewhere. Of course, to have proper case studies, you also have to have smaller case studies. But the question whether the transnational case and the domestic case are really different or not. And that's your question, is also Judith's first question, remains an open one in that, right? First, are they really different? And second, are they treated differently? And second, are there any truly local cases? Aren't all local cases also affected in some way from by globalization? So I see, maybe to move to this point, the attempts to isolate corporations from liability, also domestically. I see that in the domestic context, especially in the United States as well. I see that in your work. I see that in the dissertation I supervised, my last one at Duke University, that dealt with the arbitration decisions, quite stunning arbitration case law in the US Supreme Court. I think it's true. I still think that there is still a difference as concerns transnational cases over domestic cases, at least in the United States. And I'm surprised sometimes how that is not sufficiently recognized. I wrote an amicus brief in the Evergrande litigation, big antitrust litigation, global antitrust case, where the domestic plaintiffs were able to settle relatively easily, and the foreign plaintiffs were dismissed. And in the proceedings, that dichotomy was rarely raised as such as a problem. I would say that what we find is that foreign plaintiffs have a harder time than domestic plaintiffs finding justice in the United States because they have no political salience. They are not voters. And secondly, we find that something twofold goes on, really. The one is to realize to what extent US courts have become world courts, or were for a long time the only possible venue for certain types of litigation. You mentioned the Alien Tort Statute. That's one clear example that created this world court situation, but in other situations we had that too. And secondly, how aggressively the world court here uses that to interfere even with proceedings elsewhere, something that we find in the Chevron case, and something, of course, we found in earlier cases as well. So there is something added, I would say, in the treatment of transnational cases and plaintiffs to the treatment of domestic cases. So that on those two questions. Your other two questions concerned the colonial situation and the possibility to decolonize, I would say. Genevieve's question, I would say, is easier because Canada and the United States are settler colonies. And so your name comes from, your last name obviously comes from the colonizers, to put it that way, right? And so to say we are a victim as Canada is the we in Canada who are the victims indeed, as you know, are local communities that have probably slightly better situation in Canada than in the United States. But most of what Canada and the United States stand for now are really settlers from Europe coming to these countries. And so it's not the same as the colonial situation or the post-colonial situation in, say, Latin America, and even more strongly, maybe Africa. And the question of retrievability, I think that's a really interesting question also in comparative law. That is, the first part is, can we go back to alternative procedural institutions that were replaced by colonial institutions? I am doubtful usually, because I think often those were not so good in the first place. And by now it's very hard to retrieve those after many years. But I say that abstractly and from my northern perspective. And I know that scholars working in the global south are attempting to revive such institutions, and sometimes with success and sometimes without success. The other question is to what extent institutions that were imported from the global north can be reinterpreted to serve specific local contexts. I just heard a presentation on establishing a strong common law tradition with precedent, etc., in African countries as an alternative to the imposed common law from the colonizer. And that's the other interesting question. Once you are confronted with colonial institutions, how can you reinvent those as your own way towards decoloniality? Decoloniality would not be to say we go back to non-Southern standards. We do not just reverse the hierarchy and say that's actually what is superior to the European institutions, but to say is a way of looking at the institutions in the world that we have now and trying to understand how those can be made to fit these requirements. thank you both for your questions.
I have two additional questions, one from Rick Marcus and from Margaret Wu.
I mean, it's my turn. Thank you very much. That was an extremely interesting comment or presentation. I think I'm going to come at it from the global American North, third comment from there, from a slightly different angle. Three sorts of points. Number one, it's not common law versus civil law or global North versus global South. The US, maybe Canada too, sticks out like a sore thumb in terms of the things that we are looking at in this project already. As an English judge said in 1982, as a moth is drawn to the flame, so is a litigant drawn to the US courts. So the Alien Tort Claims Act has been, since it was somehow rediscovered about 40 years ago, become an illustration of that. But I think that that's a way to show that the common civil law dichotomy doesn't really apply at all. And the US plays the role of policeman to the world. Even in the Bhopal litigation, the government of India was urging that the case be retained in the US when the defendant sought to have it removed on forum non grounds. Point one, I'm just going to interested whether you have reactions. Point two, forum non under our doctrine is inherently comparative, and it has both substantive and procedural aspects. Since the US is so different from the rest of the world, there's always an argument that the case must be retained here because we have jury trial and the other things you mentioned. In Reno, the leading case authored by Justice Marshall, an example of a place where there was no law cited by the Supreme Court is Ecuador. So that kind of argument has been around for a long time. Third point, and Professor Michaels was an active participant in the revisions of our restatement of conflicts of law. Our internal to the US choice of law interest analysis is itself comparative in a way that seems to me analogous to some of the considerations that Professor Michaels is introducing. So the basic point is very interesting presentation, thought-provoking, and I wonder if any of this provokes any thoughts from you, except that the US is a weird place and maybe you're glad not to be here any longer.
Margaret, you have the floor now.
Yes. So I'm just following up on Judith's question, and I think Judith caught me shaking my head when she asked the question whether there's anything we can learn from the mixed courts and from the traditions of mixed courts, using Egypt as an example. And of course, there were mixed courts in Shanghai as well. And what brought to my mind is really the present day international commercial courts that's been established both in Singapore and China, and I think Europe as well, which again is in a sense mixed in that same way. And I posit really as to whether or not that is really a interesting challenge to domestic courts, an interesting really challenge to see how that could be a tradition that that draws or fights off colonial kind of colonial imposition. And I just wanted to note that, in fact, that this particular new trend of international commercial court is something that we are focusing on in our last segment. Do courts really matter? And I guess if I were to pose this as a question, then really is to Ralph, whether you have any comments about these international commercial courts in terms of colonial and decolonial trends.
Excellent, thank you both. First, Rick, I agree with all 3 points, and I actually tried to make some of them. I don't think that the common law civil, look, finally, the common law civil law distinction is interesting and relevant. From a colonial decolonial perspective, it's not extremely there are bigger distinctions than those. And I would say those have to do with power imbalances. And indeed, the United States stands out, not because it's a common law system to the extent that it is, but because of the power imbalances. So that's very central, in fact, to my argument. And I would say, and have said, that form nonconvenience is inherently comparative. I would also say that interest analysis is inherently comparative. The question then becomes, in what way is this comparison done? I mean, you suggested rightly, in theory, we could say, or at least plaintiffs' lawyers have said in form nonconvenience cases, no other forum is good enough for us because, as you said, no jury trial, no cross-examinations, et cetera, et cetera. Those are usually dismissed, right? I mean, form nonconvenience, that's by now settled that those are not valid defenses against form nonconvenience. The analysis would have to suggest in what way is form nonconvenience in fact handled? So what cases, in fact, are kept in the United States, which cases are sent out, and to what extent is that a function of the doctrine, to what extent is that the function of other factors? I would say, I mean, Burkhardt challenged me to say in the Chevron case, the corruption happens in between. And I know that that argument has been made, but taken together, it is hard to see how. So what you have to do in a form nonconvenience case is usually, as defendant, you have to consent to jurisdiction, you have to consent to not raise limitations, etc. It's not clear why you don't have to consent also to say, I will not raise the issue of corruption because I waived that by saying, I trust the Ecuadorian court, right? So you might argue that that happened in between, but you might argue also, and I think at least plausibly, that's exactly what plaintiffs predicted, to say those courts are going to be corrupt, except of course plaintiffs thought they would be corrupt in the other way. And so I don't think that's such an easy way out. And I think a comparative analysis would need to go beyond just the doctrinal comparison of different institutions, of different legal doctrines, and would have to look at, in a legal realist way, if you want, to see what are the factors in fact in which these colonial epistemologies and in which these power imbalances are translated into legal doctrine. The other court, mixed courts, arbitral courts, and I'm sorry I didn't address the mixed courts before. I always think mixed courts were a mixed blessing because the power imbalances tended to be concealed in many of these cases, right? And the same, I would think, is true in much arbitration, even where arbitration is now increasingly entered into by arbitrators from the global south, or at least formally from the global south, because usually you must have studied in some of the institutions of the global north. Arbitration itself is set up to take power away from states, right? That's one of its big attractions, both in commercial arbitration and in investment arbitration. And that is attractive where it is held against corrupt governments. But it also has the suspicion, of course, it undermines sovereign decisions of states as well. And it depends on what specifically we define as corruption or non-corruption. And so I don't want to criticize arbitration wholesale. I just think arbitration on the one hand is obviously a super important object of analysis for a comparative project like yours, because so much litigation, so much adjudication, and dispute resolution happens outside of courts and happens in arbitration now. But I think also that arbitration has had a way of ideological self-immunization by claiming that everything is based on consent, and for that reason, all these problems go away. And because we know that consent itself is a tricky issue that arises from such imbalances, and because we know that the mere numerical setting up of diversity in these tribunals does not run against the institutional character of them, that the suspicion that I would have in comparative civil procedure to this prioritization is probably rather stronger in international arbitration. Is that somewhat responsive?
Yes.
I would permit a last question from Athena Stafilo.
Thank you. Can you hear me?
Yeah.
Okay. So the problem here from the whole discussion is a problem of orientation. What is colonial? What is decolonial? Many participants said that in their questions. How can we trace colonial procedural thinking and non-colonial procedural thinking? Maybe we could say this is the time that a court in every country, in every territory, speaks the speech of the master and regards another court of another territory as a court speaking the speech of a servant. This is a power rearrangement and an arrogance in all that colonial time through these injunctions is that the injunction, the anti-suit injunction, the origin is not a colonial birth of a procedural institution. It was made at times that other courts of colonies, they were not equal in power and in value. And that corruption argument, what is corruption? The court of a state are all corrupted. Is that not racial? I mean, when we have someone that makes something is a criminal, can we say this person is a criminal and all like him are the same way criminals because they are that? Are Ecuadorian courts through this great equation all corrupted because one judge was corrupted? How can this allegation be proved at all? Is there evidence? How many corrupted judges? Are they punished in Ecuador? Has a litigant a problem with corruption in the process? What is the right way? The right way is not escaping jurisdiction, going in his own country. The right way, the anti-colonial way, is fighting, going to police, going to the press, finding evidence about the judge who is, in his case, responsible. What is this general colonial thinking? Everyone is corrupted. Our courts are not corrupted. Who says that? All that under this thinking is this power, this struggle of political and economical interests that come out in this speech of a master versus speech of a servant. I am the master, you are the servant. And now the question, could we surpass these differences through global court, a global court for human rights abuses? There is now a question. If we can't do that, many countries say no. We can have some progresses, punishing business rights abuses on human rights matters and environmental pollution, but not a global court. So my question is a global court on that matter, human rights abuses, environmental harm, right of nature, right in environment, is a human right, could be a global court in which directly a country or a population or non-governmental organizations can sue against a company, could be a solution. Thank you.
Thank you, Athena. Of course, that shows how woefully inadequate my explanation of coloniality was, and I apologize for that I didn't spend more time on that. I would say that your separation of master and servant and to define coloniality as mere arrogance of those in power over those who don't have power, that goes too short, I would say. That's certainly the origin at some point. And of course, at some point, we openly made these discrimination between functioning and non-functioning legal systems, and blatantly and openly turned those into advantages of certain countries over others. And it's really become more subtle and more dispersed, if you want. So the idea of coloniality, the idea of these inherent hierarchical differences is one that permeates thinking in the global north and the global south alike. But not that the master speaks and the servant listens. It's rather that an epistemology in which the institutions of the global north are inherently superior to those of the global south, is that we find both in the global north and in the global south. We find lots of Latin American lawyers and scholars who say we still have to learn a lot from the global north. We find that strongly, I find, John, in Japan, the frequent talk about we have to learn more from Europe or the United States, although in complicated and sovereign ways. So it's not that. It's really to suggest that an epistemology that we hope to be universal and to hope to be neutral is in fact not universal and is not neutral, but recreates and at the same time conceals certain imbalances. That's found, just to use your example, in corruption. In corruption, we have a fair amount of studies, right, that ask about the contingencies of what counts as corruption. So it's corrupt if I get a speedier service in a local African administration by bribing the clerk and handing him $100. It is not corruption if I pay an extra fee in the United States for expedition of my visa application, right? So from a functional perspective, both of those do the same thing, right? They prioritize those with greater desire and bargaining power from those others, and puts money into the system, except that the system in the United States goes into the general system and then into salaries, whereas in some African countries, the money goes directly to the clerk because he's not paid enough, but that may be efficient because it cuts out the middleman, right? So I'm exaggerating here. I'm just saying on corruption, we have these studies that say we have a certain seemingly universal definition of what corruption is that turns out to be based on a specific institutional setup in which corruption is not necessary, or in which side payments are not necessary, and universalizes that. And so those are, and that's your last question, why I don't think a global court would really solve these at all. A global court would not enable the pluriversality that lies at the heart of decoloniality. A global court would, in all likelihood, enhance the universalizing aspect that comes with coloniality. It's very hard to see such a global universal court as one that can truly account for this pluriversality. My hope indeed, and that's of course my own disciplinary bias, lies in the decentralized procedures of private international law, where we have these plural perspectives, maintain these plural perspectives, and courts from different systems, from different jurisdictions have to mutually observe each other, mutually respond to each other, mutually take into account the perspectives of the other, as if you want, in terms of institutional setup and in terms of doctrinal space, the closest that we have to an approach to pluriversality. And so the farthest, if you want, is the idea to have actual universal courts, because universal courts would run directly against this idea of pluriversality.
Ralph, you ended your answer with by addressing perspective and the plurality perspective. And I think this was quite important because research depends very much on the perspective a researcher takes. And this is a challenge for us. And we have to look at the political dimension, at the power which is behind justice systems. But this project has to be diverse, and we try to have teams which are composed by researchers from different backgrounds, different countries. And the project is also about justice. And I think here we have maybe some values. I would nevertheless say they are universal. They are important to be universal. Also, the world is quite diverse. And we have, and this is my last reflection here, also a different kind of centralized and maybe neo-colonial views. These are the so-called doing business reports, where court systems all over the world are measured in a very rough way. And one has also to ask whether this is always the right approach. It's certainly not the only one. So with these reflections, thank you again. It was very much thought-provoking and a very good moment of our project. I would like to propose that we will continue with John Haley in 15 minutes.
15.
Thank you very much. And thank you everyone for the questions too.
Well, welcome back, everybody. Waiting for people to slowly put their cameras back on. You know, this has been a great seminar, and there's really no better way to follow up on Ralph's charge to us, that is to kind of view our project with some caution and to take on a decolonial lens. And there's really no better way of doing it than perhaps through history and the methodology of history. And that's why it is so great to actually follow up Ralph's presentation with John Haley's. John Haley is an internationally recognized scholar of comparative law and Japanese law. He is the professor emeritus at Washington University at St. Louis, affiliated at University of Washington School of Law. He has written many, many books, comparative law, and I'll just highlight two that's relevant to our project. One is The Fundamental of Transnational Litigation by West, and the other is Law's Political Foundation, Rifles, Rights, and Religion, published in 2016. And so why don't I turn it over to Professor Haley for his comments on the historical methodology.
I think in the last conversation, people mentioned perspectives. Well, Professor Michael's perspective was like a microscope. Mine is like looking at the world from the space station. It is as broad as you can get as an historical perspective. And there's perhaps some definitional issues that I need to at least mention. When I talk about law, I distinguish it from non-law in the sense that you can have various mechanisms of dispute resolution, various mechanisms for interconnections among parties, but the legal connection means state law. That is the law that is set out, formal institutions like statutes, regulations, but not through custom, through continued relationships. Let me give you an easy example of this. The largest source of foreign investment in China today is Taiwan. But there is hardly any cases where the Taiwanese investor has engaged its investee, the party with whom it's investing, with a contract. They don't have lawyers. They don't have standard forms, and they certainly don't resolve their disputes in the context of formal litigation or arbitration or any formal process, but rather it is through a continued relationships. The investment is through people who know each other, who have some connection, who have been introduced. It is customary, and it's particularly apt for southern China, where most of the Taiwanese investment goes, because there are all sorts of personal family connectedness between persons living in Taiwan and persons living in southern China. The next problem is one within my definition of law. And when we talk about, quote, civil, unquote, dispute resolution, we're talking about private law. We're not talking about public law. And I make the distinction. Private law is a system of law in which you have courts, you have legal rules, but the process itself is initiated by a private party. And that same private party, the plaintiff, has complete control or almost complete control over the process. They can withdraw their suit, they can settle, or they can pursue it until the court denies their claim. They make the arguments based on the private law. And so we think of civil law systems, common law systems as essentially private law systems. I'll come back to that. But there's another set of systems which I call public law. And all administrative and criminal law is public law. And the distinction again is I can file a complaint in a criminal case. And once I file the complaint, the criminal process takes over. They deny my complaint, they deny it, they begin a procedure, but I lose as the private party, the complainant, control. It is all up to those who administer the system. And the same is basically true with administrative law, although in our systems, and particularly the US system, administrative law has a lot of private law structures to it. And we'll come back to this. And finally, a sort of introductory remark. In my view, there are two fundamental systems in the world that are diametrically different. No systems are as different, and no systems are as unique in the world as the United States and Japan. But they are absolute polar opposites. We can go into that in questions. If you want to ask me about judges and corruption, I'd love to talk about Japan versus the United States. But in any event, we'll put that aside. To go to my primary part of the presentation, what I was asking myself is, what does history tell us about civil dispute resolution? And the first of all is that when we're talking about history, there are a number of approaches in history: institutional history, economic history, intellectual history, cultural history. But my primary focus is on political history, because I think that law and politics are so closely interrelated that you cannot separate the two. The foundations of law are predominantly political. The second issue under politics is today throughout the world, no matter whether you're talking about colonial or post-colonial or north-south relationships, every single country almost, I put Saudi Arabia aside, have either a, quote, civil law or a common law system. So the world has a unified legal system. We can make a whole set of assumptions about the institutions, but those institutions we know historically are founded, at least on the civil law side, in Roman civil law. And the origins of Roman civil law can go all the way back to the city of Rome and the 12 tables, but did the 12 tables ever apply to much outside of Rome, initially or ever? How much of the Roman Empire was subject to corpus juris civilis? Well, I suspect, I'm not sure, historians who know more about this than I do can educate me, but I suspect that almost no part of the Roman Empire was ever subject to the corpus juris civilis. That Roman law was basically military rule. You pay taxes, that's law, and you maintain order. But most of the rules that applied in everyday life were local customary rules or some legal rules by those who have political power in the communities that the Romans conquered. And so they had a military occupation stretching from England all the way through Egypt, but the law in these places, for the most people, had nothing to do with the corpus juris civilis. It was local and customary, or some formal aspects, perhaps, depending on who continued to rule. So where did our contemporary Roman law system, whether it's common law or civil law, come from? When did it begin? Well, we know it began in the 11th century, when an Italian scholar discovered texts of the Corpus Juris Civilis in the Justinian Code, which had never applied in most of Italy, and never, ever in any part of Western Europe. He discovered it. He was a professor, and so he began to teach it. Well, at the same time, the university systems of Western Europe began to develop. And so you have, by 1500, 70 universities. And when they were talking about law, they were teaching the corpus juris civilis as an academic subject. But it meant that anyone studying law in Western Europe or at any of these universities was learning Roman private law. Now, how much it applied throughout the system is, we don't, at least I don't know. I know, yeah, I can look at France perhaps, I can look at Spain. Spain is a good one, and England. But remember in England, that meant that at least at some point, every judge, if they were required to go to the university to become a judge, every judge had been trained in Roman civil law, except one major European country, and that was England. Judges in England, even today, are not necessarily university graduates. And even if they are university graduates, they didn't necessarily study law. Where do lawyers or judges come from in England? Even today, the vast, vast majority of all English judges were barristers before they became judges. And to become a barrister, you didn't have to go to the university. You didn't have to study law. You learned law through apprenticeship through the Inns of Court and in chambers where you were an apprentice for a period of years. Then you become a barrister, and then maybe you become a judge. So at least in the English case, even judges barrister judges, at least have an understanding of law, and the law they understood was common law as it developed and incorporated principles of Roman private law. Now, when we look at legal systems in the world from today's point of view, a contemporary point of view, what do we discover? Well, we discover that there are codes. And when did the codes begin? The civil codes and codes of civil procedure, where did they begin? Where did they start? Well, you know that they're all national codes. So before you have a civil code or a code of civil procedure, you have to have a state. When did states in Europe begin? Well, I looked at the world in, let's say, 1500, and what states had formed in Western Europe, or in Europe, put it that way, in particularly Western Europe. Well, in Western Europe, there are only maybe 3.5 states by 1600 that had formed, or 1500 that had formed. England was among the first, Portugal the next. Oh, and I should add, why did England and Portugal become states? A single ruler that controlled them, and the borders are almost the same as today, because those rulers controlled all the rivers within the territory. Portugal was easy because they're short and they flow to the west, and the mountains separate them, so Portugal was easy. England, you could control 2 of the 3 major rivers that flow only in England, and you have an English territory. You could never do that in Europe. France gets close, and France is the next, but the rest of Europe, no single country controls the Danube today. No single country has ever controlled the Rhine. And the other rivers flow through what have become many countries. They're not the same kind of natural barriers. In any case, when we talk about nation states, we're not talking about something that starts 2,000 years ago. We're talking about something that began less than half a millennium ago. So when did the codes begin? Well, we know the first national code was what is called the Siete Partidas, or see if I can get it correct, the Spanish, I had it written down somewhere here, Libro de las Leyes. This was the Spanish code in 13th century. That code the rules in that code still influence the law throughout Latin America, throughout Western United States, although the code doesn't exist. But it was the first code, and it became the most extensive code throughout the world, and perhaps even today as a national code. There's at least one or two codes in Germany or the Austrian-Hungary Empire before the 19th century, but the first major national code that had worldwide influence was the French Code of 1804. Now, I should add, we think of the French Code of 1804 as having influenced Louisiana. Well, it's true. The French Code of 1804 did become the basis for Louisiana law. Louisiana is the only civil law jurisdiction in the United States, but it was adopted in Louisiana by Louisiana state legislature in 1834. Spanish law governed throughout the Western United States, including the Louisiana Territory. In fact, I noted the other day that when the Louisiana Territory was purchased from France, which had only had the Louisiana Territory for a few years, the representative of the United States went to New Orleans to receive title to the to New Orleans, and he was told by the French governor of New Orleans when he was going to go up to St. Louis to receive the same kind of documentation from the governor in St. Louis. He said, well, you have to understand, we haven't changed governors in St. Louis. The Spanish governor still is there, or the representative of Spain is still there. So when you go to St. Louis, we would like for you to represent France. So you first thing with your left hand, you take the documents from the Spanish representative, and then on behalf of France, and then from your left hand to your right hand, you take it from France to the United States, just to give you a sense of how extensive Spanish law was and how long it extended in Hispanic America all the way through the Philippines. So what was the next code? Well, the next code, which was a century later, the German Civil Code, 1900. Between 1804 and 1900, if you wanted to adopt a Western law system, you looked at the French law. And the first, I should back up a little bit. Looking at 1900 versus 1800, the beginning of the 19th century. The 19th century, I would point out, is the critical century for legal history. But in 1800, there were no steamboats. There were no steam engines. If you wanted to travel, and for thousands of years throughout the world, if you wanted to travel, you had to use your feet. You walked, or you rode in a buggy that was driven by donkeys, mules, buffaloes, or whatever. But it took days to go just a few miles. And so communication was very, very slow. There were no telegraphs. There was no radio, and there's certainly no internet. So it took enormous amounts of time simply to get a message from one community to the other. Now, for law, that means it was very difficult to have a national law that had an application and access to 95% of the population. Maybe if you lived in London, maybe if you lived in Madrid, maybe if you lived in Mexico City, you had some access to courts, but you certainly didn't have it in where most people lived. And most people were living in local communities. The governance of that community was landlords or someone outside of the national orbit, or unless they had a delegated authority to rule and collect taxes, for example. So what happened between 1800 and 1900? Well, the Industrial Revolution. And starting with England and then Western Europe, and then throughout the Western Europe, the Industrial Revolution meant steamboats, trains, no longer relying on canal and rivers. And rivers were important for transportation. But I don't know if you've ever tried to take a canoe up the Danube. It's very difficult to row yourself against the current. And so if you go downstream on any major river anywhere in the world, it's relatively easy. The flow takes you. But going upstream before the invention of steam and the steam engine was extraordinarily time-consuming and difficult. But what happens in the early 19th century is the Industrial Revolution, and you have steamboats and, most important, gunboats. And you look at the history of European colonization and European expansion in the world, it's a 19th century project resulting from the Industrial Revolution. Why did the English and the French win the Opium Wars? Because they had steamboats that could go up the Yangtze. Why did the United States do so well in the second half of the 19th century? Because they had a war in the middle of the 19th century in which they perfected all sorts of military equipment, including boats with armor plating. I'll come back to but by the end of the 19th century, Western Europe, particularly England, the Netherlands, Germany, and France ruled most, and Spain. Well, Spain had ruled most of the world, but by the early 19th century, Spain was a has-been. They had spent all the gold that they had acquired. It was almost bankrupt. The Spanish Empire, by the middle of the 19th century, had ended, except for the Philippines, which ended in 1898, another point. So at the end of the 19th century, I've lost my, I've just lost, oops. Okay. I don't know what happened.
It's all right. You can give yourself, I think we could give you a little time to find.
Yeah.
Okay, let me get, there we go. All right, excuse me. At the end of the 19th century, how many fully independent countries existed that had never been influenced by, perhaps, but never been controlled by a European power, or were not part of the Ottoman Empire or the Russian Empire? I found one in Africa. Today we call it Ethiopia. There's only one in the Middle East, which we call today Iran, Persia then. And then you have some Himalayan kingdoms, and then you're in the Far East. Thailand, Japan, and China. Never, ever controlled by anyone other than China, Japanese, or the Thais. Influenced by, at least in Thailand, but not controlled. What happened in Japan? And my argument is, for all of the countries that were fully independent, not part of a colonial empire, Japan becomes the model. As you may have heard or remember, there was an incident in the 1850s where American gunboats, steam-powered gunboats, entered Tokyo Bay, the Black Ships. And the Japanese were duly impressed. And they changed their government, and they decided, with a very short period of time, thinking going back to Chinese legal system, of adopting Western culture, Western institutions. And it included Western law. And they first looked to France. So they brought in a French scholar to draft a code. But by the end of the century, the German code was, at least a draft was available, and the Japanese turned to the German law because I always wanted to do what was the most modern and up to date. Now, by 1900, the United States and Japan became world powers, almost exactly at the same time, and for exactly the same reasons. And they put themselves in very close proximity. What did they do? Well, the United States in the Spanish-American War took over the Philippines. And Japan, fighting China, took Taiwan. And you could actually, with a very high-powered telescope, see parts of Taiwan from parts of the Philippines. They're very close. What does that have to do with law? Well, the United States introduces its legal system, just like the English and the Dutch, etc. And the Japanese introduce, they didn't introduce their traditional legal system, which was, by the way, China borrowed. They introduced their legal system, the modern system based on, in 1895, a mixed, but certainly by 1900, a German-based system. So Taiwan moves from a traditional Chinese law system to a German-based Western system, and the same happens in Korea in the early 20th century under Japanese rule. Today's Korean Civil Code and Code of Civil Procedure are basically the same as Japan's, with some interesting in the Civil Code, some interesting additions which were part of Japanese case law, which were incorporated in the Korean Civil Code. So the world, all of those countries that are independent now have either civil law system with civil codes, or they're a common law system. Now, the only countries that we call common law systems were former English colonies. So Canada and the United States are former common law systems. I'd love to answer questions about differences within common law systems of the judicial system and how unique the United States is, and why looking at litigation in the United States and choices of using the United States for litigation may have less to do with the law than with the judges. In any event, am I almost out of time? Grief. I've done it again.
You just have a few minutes, so.
Okay. Well, let me figure what I'm doing here. Okay. Can you see me and hear me? No,
yes,
you can't.
We can see and hear you.
Well, I don't have to have
why don't do you want to conclude?
Anyway,
let me questions.
Let me do questions. Let me just sort of end with my final comments.
Yes, please.
When we look at the world today, remember that after World War I and then World War II, the Russian Empire came to, and the Ottoman Empire ended in World War. At the end of World War I, the Russian Empire re-established itself. But if you look at the world today, you find national systems. There are all the former colonies were independent, but the former colonies, like the United States and Canada, there were English colonies, adopted the English common law system, and the newly emerging states who were former colonies of a European power. If it was French, they adopt French law. If it was Dutch, they adopt Dutch law. So Indonesia has a Dutch law system. Vietnam had a French law system. Now it's sort of a mix with influence from the socialist system. But North African French colonies have a French code. And so they follow the colonial system. Interestingly, to go back to judges, in almost every case, the persons who became judges, leading people in the judiciary, immediately after establishing independence, were those in the colonies, the persons in the colonies, who were working in the judicial system or in the legal system, but they were secondary to the rulers. Then they were the most educated in law, and they become the judges. This is true in Korea. It's true throughout Africa. It's true in Indonesia. There's one major exception, and that's Taiwan. The lawyers and judges who were trained under Japanese colonial rule disappear. None of them practice law. None of them become judges. None of them, they all are out of the legal system. And the reason is because the nationalists from mainland China came in 1945, and these were leftovers from the colonial regime. The new system was the nationalist system that was developed within mainland China. Final point, when we look at the world today, we see that it is predominantly a public law system rather than a private law system. And if you want to go back to the roots of a public law system, you have to go back over 2,000 years ago to China. Imperial China had the longest period of peace, and it had the longest enduring public law system. And in a way, we look a lot more like China than we look like 19th century England. And I'll stop there.
Wow. Well, that's really interesting because, and thank you for your, kind of detail and global analysis of really gunboat diplomacy and how we could see that law follows gunboat diplomacy. And it's essentially what Ralph was trying to emphasize, and that we need to recognize that, in fact, many legal systems are, in fact, part of a colonial tradition. And you've illustrated it very nicely. But also what's interesting is that you ended it with China and Taiwan, and how nevertheless, if you examine it carefully historically, you will still see some historical tradition that seeps through. And for all of us working on this project, that's what we're going to have to try to figure out, which part of it is really from gunboat diplomacy, and what's from really inherent kind of traditions of the particular nation. I open it up for questions, but I actually, one thought as you were talking about that I thought would be really interesting for us to speculate is whether we're actually seeing a growing new colonization, and primarily US and China. And again, I'm referring back to these international commercial courts that China is trying to set up throughout the Silk Route. And essentially what they're doing is yet importing their legal system, but yet, and through economics, within countries that have entered into these Silk Belt and Road initiatives with China. And so we're still seeing colonization happening in some form or fashion. But I'll be curious if you have any thoughts about what's happening today with the US and China kind of infiltrating their legal regimes abroad. But I'm also, I see here there are 4 new messages, so I guess we have questions, and I really would open it up for questions. But John, do you have any thoughts about how the US is importing its legal system and China is importing its legal system today?
I don't think we import our legal system. People, as Mikhail mentioned, people use our legal system because our legal system provides the best results, at least in terms of money, and for lawyers. The critical problem, I think, for any legal system is the law matters less than the judges. The judges are the ones who interpret and apply the law. And the United States, I'm going to again contrast Japan and the United States. The United States is unique in that we have, except in 3 state jurisdictions, all in New England, and the federal courts, all state judges are elected for a court. And in a significant number, they are partisan elections. And they are all reelected because nobody knows the names of judges. And so we have a system that is totally politicized in our judiciary. Mm-hmm. Secondly, in the federal system and in 3 states, it's appointed in a couple of states, in at least one state I know, it's for a term, or if there's a mandatory retirement at a certain age. But Japan's system is the total opposite, and there's no system that is like it. All judges almost every judge in Japan became a judge as an assistant judge in their 20s. And they continue until their retirement age, which I think is about today, between 60 and 70 years old. They remain. Half the judges in Japan have been judges for their entire lifetime. They don't, if you want to stop being a judge, you may become a lawyer. That's easy to do. The second thing about Japan is last time we talked about corruption. There is not a single case that I have been able to find, and conversations with judges at every level, from the Supreme Court all the way down to local levels, former students, lawyers, not a single case in my lifetime, and maybe before, of a Japanese judge taking a bribe. Not one instance. Now you find me a legal system where judges don't take bribes. Now it's understandable because judges don't go to a single court. They're appointed as judges in their 20s, and the first appointment is down in Kyushu or in Okinawa, and the next appointment is up in Hokkaido. They move around, and they also move around from courts. They're appointed to a district court, of course, at first, and then they're appointed to a high court. Then they come back to a district court each time as they mature and as their status is more, they've been there for a longer period of time. They go to a higher position. So you have on a 3-judge panel, which is typical in a trial case, usually an assistant judge, became a judge within the last 10 years, a middle-aged career judge, and then a more senior judge. And they all move around. So judges know each other. And there's a central agency within the judiciary that appoints the judges, that moves them around. And if I have a good reputation as a judge, I can move up. If I have a bad reputation, I'm not going to get good appointments. I'm not going to go into Tokyo or go into Osaka or Kyoto. I'm going to be out there in the rural districts. And I did an experiment once. There are a couple of cases where you have district court judges who are making decisions which contrary to what the Supreme Court had said, contrary to precedent. And I looked at these, and I think their careers are dead. How can this judge do this? Because he's going against the established judiciary, not the establishment in Japan, but the establishment within the judiciary. And in every case I found, the chief judge of that court was in his late 50s, early 60s. They're about to retire. They're not going anywhere. So they're free to do what they want to do.
Interesting. Well, I do see there's a question here in the chat from Guantian 2. Do you want to unmute yourself and ask your question? Is somebody, or Rick, do you have a thought?
My thought was gunboat diplomacy, I would call it, involving Japan. 1905, Russo-Japanese War, shock of Russians. The Japanese won the war. I mean, it's a very intriguing counter story to the one from the first presentation. I'm not sure what we make of it. And you might add to it, after World War II in Japan, the Americans tried to introduce procedural elements of American systems, which basically, I think, evaporated over time. I wonder if you could say a word about that effort to transplant American legal systems to Japan after 1945 and what became of it.
Mm-hmm. Thank you. Thank you.
Do you want me to answer now or wait till all the questions?
No, why don't you?
Well, I know a little bit about the American occupation of Japan, and you should know that the person responsible for legal reforms in Japan, the occupation committee, was actually Austrian, Dutch. And his deputy was an American lawyer by the name of Thomas Blakemore. Blakemore had studied in Japan before the war and had Japanese language ability. And Blakemore insisted that the Japanese system was quite modern and equitable, and it was a good system and did not need much repair. He was most emphatic with the criminal justice system, but there is very, very little US influence on the Japanese legal system, except in the Constitution. And there are two aspects of the Constitution which are interesting. I'm not sure you've ever read The Only Woman in the Room. She actually wasn't the only woman. She was the translator, but there was a stenographer. She was delegated to write some provisions for the Constitution, and she was interested in women's rights. And she had been translating, and Katie's turned and said, she went to the restroom for a minute, and he turned to his Japanese colleagues during the negotiations over the Constitution and said, she's worked so hard, don't you go give her something? And so they agreed to include Article 24 of the Japanese Constitution on women's rights in the Constitution as it exists today. But other than that, there's remarkably little influence by Americans on the formal legal system. The influence is in other statutes, antitrust law, et cetera, which were not done by the Law and Courts Division. I'd like to come back. It's not so much gunboat diplomacy that I wanted to emphasize, and I didn't do it. It's the 19th century was the era of relative peace in Europe. There's no major, well, there's the Franco-Prussian War, but there's no major war in continental Europe during the 19th century. It's the most peaceful century in the history of Europe.
1815.
Yeah, that's
1815.
That's right. Excuse me. That is during the Napoleonic era. But after the Napoleonic era, it's peaceful. What does it mean to be peaceful? What it means is you don't have to spend money on armaments. And if you don't spend money on armaments, you can put it into other parts of your political system. So you look at China. It didn't have to maintain a huge army because it had few wars, and they could create a public law system of administrators, people who were adjudicating criminal cases. They didn't need to rely simply on private law and judges, where European countries, the territories, polities were constantly engaging in war, so the rulers had to put their resources into soldiering, hiring soldiers in many cases, rather than creating an administrative system. It's not until the end of the 19th century, and particularly after the First and Second World Wars, that you begin to have the public law systems of Western Europe, including the European Union.
Mm-hmm. Okay.
It's a resource issue.
Okay, Guan Jian Tu, do you want to ask your question? Your hand is up. Yep, thank you.
Yes. Can I? Yeah, just now actually.
Can you turn up your mic, please?
Okay. Because not in the. In the sitting room. In the sitting room. Sorry, I just asked the question. Just now, Professor, the presenter said the young judges in Japan, right? Can you hear me?
Yes.
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 Right now.
Actually, do you think it is a good thing that such young judges decide cases for civil cases, especially like marriage cases, divorce cases, things like that? To me, I don't, actually China learned the same. When I graduated from the university, at the time, many judges actually in the court were 20s, 30s, things like that. To me, this is not a good thing, rather a bad thing. I know probably no corruption, but in terms of the whole machinery of judiciary, probably I don't think that is a real good thing. Thank you. So what's your opinion?
Well, first of all, there are very few cases that are handled by a single judge. In almost every civil case, first trial, there are 3 judges. One is a senior judge, usually in his 50s or early 60s, a middle-aged judge, 40s, 50s, and then maybe a younger judge, an assistant judge who'd be in late 20s, early 30s. But there's never a case, a major case, which is heard by a young assistant judge. And you are an assistant judge for your first 10 years. So you start, let's say, at 22, and you become a full judge at 32, whatever. So it's never a single judge in Japan.
I know always there are 3 judges sitting together to decide a case.
That's right.
But the situation actually is normally there is a presiding judge, and the presiding judge actually, make I would say make most decisions, and mostly depend on.
No. There are 3 judge panels. There's a case. The judges decide that there's one judge that is going to handle that case, but they don't tell the parties. They don't tell the lawyers. That's an internal issue. Now you can figure out who that judge is because they ask the most questions. But that judge will draft the first opinion, but it's got to be approved by the other two judges, and the senior judge on the panel is going to have an enormous amount of influence. And in some cases, the senior judge, if it's a major case, will take over, and the other judges will follow the senior judge's points of view.
Another question I would like to ask you is, just now you actually shared the general global legal history. Your presentation is actually about how that legal history would influence dispute resolution of civil parties. So I would like to listen to you which kind of conclusions can you draw from that legal history for dispute resolution between private parties?
Mm-hmm.
I'll draw two conclusions. Let me from what my understanding of the legal history, I draw two conclusions. The first conclusion is that all formal cases in civil courts are going to be decided by under the Civil Code of Civil Procedure and the Civil Code or some statutes. And in the cases of the Civil Procedure and Civil Code and the basic procedures, they will be of Western influence. They'll be like continental Europe civil law or common law systems as developed during that country's political history in its colonial period. But the judges will not necessarily have any connection with the colonial period, at least today. And so I want to know more about how the judges are appointed, who they are, et cetera, because they will be making the decisions within this world. That's the formal system. But in almost every country, most civil disputes are resolved outside of court. They're resolved between the parties. Now, if I do have a contract, I'm going to invest in a company. I may choose a Wall Street company because I'm going to make more money, and then I have no connection with them. But if I'm going to invest in a company in a local business, or I'm going to invest with somebody, it's going to be somebody I know and trust, and we're never going to go to court. We're never going to go to court. So we have informal dispute resolution in the United States, in Japan, in China, in every country in the world, and the number of cases is far greater. We can't count them, but it's far greater than the number of civil cases.
So that's really interesting, actually. I mean, what I'm hearing you say is that, in fact, that in procedure, you would categorize that particularly civil procedure is heavily Western from this global history. Maybe the substantive laws might be much more taken from kind of the traditional native traditions, and but if you're going to do formal dispute resolution, that it's very much a Western influence. That I think it's interesting.
Show me a national civil code of civil procedure or civil code anywhere in the world. It does not reflect European origin.
Okay.
Can I ask a follow-up question?
Follow-up question. And then I think we might have to end soon, but go ahead.
Okay, sorry.
No, that's all right.
Western procedure obviously includes common law procedure and civil procedure, right? And we know actually the civil procedure in common law is quite different. It's very different from the civil procedure in civil law, right? So the general global legal history.
Not necessarily. You have to be very careful. Be very careful that you don't confuse the United States with common law systems. Let me give you a simple example. The United States has.
Oh, you're frozen. Do you want to finish your question while John kind of loads up? Oh, John,
for all the English-speaking provinces, because the Supreme Court of Canada and Australia and New Zealand is the Supreme Court for each of the provinces, so you can have common law, not statutory law, common law that's unified. We can't do that in the United States.
Let him finish his question, and then I think we're going to have to wrap up. I'm seeing some people have to go, but go ahead. Finish your question, please.
You ask me?
Yeah, because We got distracted.
My question is, you know, the different common law procedure and civil procedure, I would say they both have their very distinctive features. So how the global legal history has influenced, you know, because just now you said, okay, actually influenced by Western procedure. Within Western procedure, there are two branches. So how the global legal history has influenced that two different branches of Western procedure.
Okay, and then we'll finish with that question. Yeah, go ahead.
If you look at all former English colonies, or at least almost all that I know of, India being one of the most significant, you ask, what is the legal language in India? English. What is the legal language in French Morocco? French. What is the legal language in the Netherlands? Well, I'm not sure exactly what it is, but I'd be willing to bet that you have clearly a Dutch-based civil code of civil procedure. And if you're going to study law, if you're from Indonesia, I recommend you go to the Netherlands. That is not to say that local custom, local patterns do not influence the system, but it influences, I think, primarily through the judges and through the extra legal system. That's where it's important. But the world is divided between civil law systems and common law systems, and common law system and civil law system have a core that's the same. The core comes out of Roman law.
Well, we're going to have to sit back and think about that. And I bet in our various jurisdictions, and there are 150 people working on this project, we might find some debate on this conclusion, but that's really fascinating. And thank you.
Well, I hope you send my paper.
Yeah. Burkhard, do you have any thoughts? We have to remind people that this actually is recorded and it will be uploaded later if you want to revisit some of the lectures and conversation. And Burkhard, I think we have another webinar scheduled. Maybe we can remind folks of that as well.
Well, let me say we have listened to two very inspiring presentations today. And when I take up John's presentation, I would say he has demonstrated that we have common roots in the legal systems, coming from Roman law, that then the 19th century was extremely important for state building and also codification, and has really impacted and still impacts of our situation of today. Of course, many legal systems were imposed. This was Ralph's point with colonialism, and they may still be seen as being imposed. We talked about mixed tribunals today, and this is a very good example of an imposed court system, structurally unfair because it privileged some parties who were permitted to go to these courts. And what I really found striking in this regard is that these mixed arbitral tribunals also existed in Europe after the First World War. And these were special courts where the enemy parties, so the Axis countries and their nationals, were treated differently from the Entente parties. So this system was very much disregarded in some parts of Europe, as you might consider, but this also demonstrates that it is not necessarily always a colonial issue, but it's of course power, which is often behind the law. Then the law becomes unfair. So thanks again for these very interesting presentations of today. And Margaret, you're right. We have a next webinar on the 2nd of July. It will start 1 hour earlier than today. And we will listen to Bruno Defin from Paris. And he will talk about comparative procedural law and economics. And we will listen to Remco van Rie from Maastricht University, who will address the use of foreign models of civil procedure in national law reform, lessons from history. So
we'll continue this conversation.
We will continue, and I wish you all a very nice day, afternoon, evening, whatever. It was again a great pleasure meeting you all online, and hope to see you on July again.
Thank you very much.
Thank you so much, Sean. And thank you so much, Ralph. I don't know if, yeah, thank you.